Hello, and welcome to our presentation on understanding workers' compensation disputes. My name is Jeff Carruthers. I am the Regional Director for the Southern and Eastern Regions of Hearings.
And I'm Kara Squire. I'm the Appeals Panel Director.
Kara and I are going to discuss the different types of disputes that can arise between system participants in the Texas workers' compensation system, such as disputes between injured employees and workers' compensation insurance carriers, and how parties to a dispute can access the DWC's dispute resolution system to seek an adjudication of those disputes. So we would like to first start our presentation with a discussion of the structural makeup of the hearings department. First, we have dispute processing, which houses our docketing staff who are responsible for matters such as the scheduling of proceedings. These proceedings include benefit review conferences and contested case hearings. Also in the dispute processing area, we have staff called proceeding resolution officers. Their job duties include providing administrative support to our benefit review officers and administrative law judges. So second, we have our presiding officers. Presiding officers are our benefit review officers and administrative law judges. Presiding officers are stationed in our field offices throughout the state. Our benefit review officers preside over benefit review conferences, which are held virtually via Zoom, and our administrative law judges preside over the contested case hearings, which are held in person at the appropriate field office. And so next, let's discuss the types of disputes that we see brought in the DWC's dispute resolution system. So Kara, what kind of disputes do we see in hearings?
Well, we're going to see different types of disputes. You're going to start with a benefit dispute. This is a dispute that deals with the compensability of the claim that can also not only include a completely denied claim, but also extended injury. And it's also going to be a dispute that affects the amount of income benefits, or actually the eligibility for those income benefits or death benefits. These are just a few examples of those types of disputes. As I mentioned before, compensability, extended injury, disability, that's going to be the amount of income benefits that's affected, maximum medical improvement, impairment rating, finality, and then supplemental income benefits. These are just a few of the examples of what we typically see. The next type of dispute, this is a dispute of an official action by the division that is allowed per statute or commissioner rule. Typically, these are going to include the request for designated doctor, the approval or denial. Also for the denial only of a benefit review conference, that does not include an approval of a benefit review conference. You're also going to have application for attorney's fees, change of treating doctor, and then you can also dispute the division's determination on an extension of MMI for spinal surgery. The medical fee dispute is a different process. This is typically when somebody is dissatisfied and wants to make a dispute through the medical dispute resolution process. And so you'll get a decision from the division, and then if you're not happy with that decision, then you can appeal it through a benefit review conference. Now, this actually, if you're not happy with the benefit review conference determination, then you actually go to the state office of administrative hearings for a final determination. So this is different. It's a different type of dispute. So it actually can go to a benefit review conference, but it stops in our area at the benefit review conference. Then it will go actually to SOA, or the State Office of Administrative Hearings, for a final determination. So you're not going to have a contested case hearing. You're not going to have an ALJ with a contested case hearing make that determination. So we've never seen one.
And those type of disputes, they involve disputes over medical bills?
Yes.
Okay.
So a medical necessity dispute actually is going to be an appeal of a determination from an independent review organization. So what typically happens is a doctor will request medical treatment, and you'll go through a utilization review, and then it will go to an independent review organization for a determination on whether or not that treatment was medically necessary, and it'll apply the official disability guidelines and make that determination. Now, if you are not happy with the decision of the IRO, then you can actually appeal to a medical contested case hearing. And then that will be the issue, will be whether or not the preponderance of the evidence is against that determination for the independent review organization. Now, this is also a little different. So it's not a contested case hearing. It is a medical contested case hearing. There's different evidence that's involved. You actually need to have expert medical evidence to support your position. You're not going to have a benefit review conference, and you're not going to go to the appeals panel if you're not happy with the judge's decision. That will actually go straight to judicial review.
So next, let's talk about the parties that we see in dispute resolution. The parties we see in dispute resolution are most often the injured employee and the workers' compensation insurance carrier. So for example, if an injured employee's workers' compensation claim has been denied by the workers' compensation insurance carrier, the injured employee may request dispute resolution before the DWC to seek adjudication of that dispute. An insurance carrier may seek dispute resolution before the DWC, for example, when it disagrees with a designated doctor's certification of maximum medical improvement and impairment rating.
So Jeff, if an injured employee wants assistance with the dispute resolution process and they're not comfortable proceeding with their own knowledge and they want to get assistance, how do they do that?
Well, an injured employee has several options. First, the injured employee can retain an attorney to represent him or her in bringing such a dispute. Alternatively, the injured employee can request to be assisted by an ombudsman who is employed by the Office of Injured Employee Counsel. Alternately, we don't see this too often, but an injured employee can proceed pro se. Now, as far as insurance carriers, they are typically represented by an attorney or the adjuster at the benefit review conference and contested case hearing. So, another type of person who can seek dispute resolution before the DWC are subclaimants. Texas Labor Code Section 409.009 provides that a person may file a written claim with the DWC as a subclaimant if the person has provided compensation, including health care provided by a healthcare insurer, directly or indirectly, to or for an employee or legal beneficiary, and has sought and been refused reimbursement from the insurance carrier. Rule 140.6 provides that a subclaimant may file and pursue a claim for reimbursement of a benefit that has been provided to an injured employee and is entitled to appropriate dispute resolution in accordance with the Texas Workers' Compensation Act and DWC rules. A common example of a subclaimant is a healthcare provider who has provided healthcare to an injured employee and has been denied reimbursement from the insurance carrier. Another type of person who can be a party to a dispute is the employer, but only in certain circumstances. Specifically, the employer has the right to contest the compensability of an injury if the insurance carrier has accepted liability for the payment of benefits. So now, even if the employer is not considered a party in a workers' compensation dispute that exists between an injured employee and an insurance carrier, the Texas Workers' Compensation Act does provide that employer with certain rights in relation to that dispute. And those rights include the right to be present at all administrative proceedings relating to the employee's claim and the right to present relevant evidence relating to the employee's claim at any proceeding. So to effectuate those rights, the DWC will provide the claim employer with written notice of all proceedings relating to that dispute before the DWC. And lastly, an attorney can be a party to a dispute relating to the DWC's approval or denial of the attorney's application for attorney fees. So for example, the attorney may appeal the DWC's denial of the attorney's application for an attorney fee, or alternatively, the attorney's client may appeal the DWC's approval of the attorney's application for attorney fees. So Kara, what are the steps in dispute resolution before the DWC?
Okay, so you're going to actually start out with an informal resolution, and then it would go to a benefit review conference and contested case hearing, and then after that, if you still aren't satisfied with the decision, you can appeal it to the appeals panel. And then once you receive a final determination from the appeals panel, if the party's not satisfied with that decision, you go to judicial review.
Okay, so next we would like to illustrate how a workers' compensation dispute would start and proceed through dispute resolution by two hypothetical case studies. So our first case study illustrates a compensability and disability dispute between an injured employee and insurance carrier, and the second case study illustrates a dispute between the same parties but with different issues, those issues being extent of injury, maximum medical improvement, and impairment rating. So our first case study is compensability and disability, and the hypothetical facts are as follows. So on January 17th, 2025, John fell on the stairs in the office building where he works. He twisted his left knee. There were no witnesses, and John felt some pain, but thought it would go away because he previously had an injury to his left knee that required conservative medical treatment and resolved with time. For this reason, John did not immediately report the injury to his employer. John had a desk job and was able to continue working the remainder of the day. He went home and felt increased pain later that evening. John went on a previously scheduled vacation for 3 days. So John continued to feel pain in his left knee and reported the injury to his supervisor when he returned to work. John requested to go see a doctor and told his employer that he was not able to continue working. John missed 2 days of work and he reported it was due to his knee pain. So the employer filed a first report of injury with its insurance carrier. The insurance carrier performed a reasonable investigation and denied the claim within 50 days after it received notice of the injury. So John gets the PLN-1 in the mail that explains that his claim has been completely denied because there was a lack of medical documentation to support that he sustained an injury on January 17th, 2025, within the course and scope of his employment.
All right, so our first step is going to be, how does John actually identify the type of dispute that is occurring at this point? So as we mentioned in the case study, he got a PLN-1 that was denying his claim. So your PLN-1s, these are going to be plain language notices that the insurance carrier, anytime you have a change in benefits, needs to alert you to what that reason is. And it needs to be in plain language so that you can understand the denial and why it is being denied. And so at this point, John will get a PLN-1 in the mail telling him that he had a completely denied claim. If he disagrees and thinks that he does have a compensable injury, then this is where the dispute process will begin. I'm just going to mention a couple of other plain language notices that you're going to see in identifying a dispute. We have a plain language or PLN-11. That's going to be a notice of disputed issues and refusal to pay benefits. That's typically going to be whenever you see a denial for extended injury reasons or disability or income benefits, some type of that. And then we have a PLN-4, which is a notice of eligibility of lifetime income benefits, just either telling you that you are being eligible or not eligible for those benefits. And then the PLN-12 is the notice of potential entitlement to workers' compensation for death benefits. So again, if you get a plain language notice or a PLN in the mail, that's usually going to be where you can identify the dispute of where to begin.
So the first step in this dispute will be what?
Well, this will actually, we're going to take it back to that informal resolution. So hopefully, ideally, John would call the adjuster and say, I've got my plain language notice in the mail. I notice that my claim is being completely denied. Maybe there's a discussion that ensues on why it was being denied. Remember in the case study, it mentioned lack of medical documentation. Maybe John has the medical documentation. Maybe he went to the doctor and got some treatment records that actually would support his case that he had a compensable injury, and he could submit those to the adjuster and work on a resolution at that point. Now, if that doesn't occur, if there's no resolution, then he can actually request a benefit review conference.
So how would John request this benefit review conference?
He's going to do that by filing a DWC Form 45, and that is going to be the request to have the benefit review conference. Now, it's important because whatever you are getting a request for a benefit review conference, you're actually going to have to note those efforts that you did to try to have that informal resolution. And so remember, that's important while you're also doing the informal resolution. It's because it's necessary to get you into the benefit review conference, because you're going to have to tell the division what you did to try to reach that agreement.
Okay, so can John do this himself, or is there anybody he can go to with help on completing this DWIC 45?
He can do it himself. He can file the DWIC 45 on his own behalf, but if he's not comfortable with the process or wanting more education, he can also call the Office of Injured Employee Counsel and obtain assistance through them. They can actually help him file that DWIC 45. And then also another option is to retain an attorney at this point. All right, and again, with the DWIC 45, as mentioned before, the informal resolution, you're going to have to document your efforts. And so Rule 141.1 actually lists out several examples of the documentation that you need to include with your request. So pretty much just think anything that you're doing to have that informal resolution. If it was an email, if it's a phone call, you can actually write out what happened in the phone call. I talked to the adjuster. This is the information I gave them, and we still didn't reach a resolution. So things like that to document what actually happened. And then you're going to attach that to the DWIC 45. You're actually going to give the division notice of what occurred.
So after the request for BRC is filed with the DWC, a benefit review officer will review the request and either approve or deny the request. If the benefit review officer denies the request, written notice of that denial will be provided to the parties, and that notice will include the reasons for the denial. If the request is approved, a benefit review conference will be set. So if the benefit review conference is set, the DWC will send the parties written notice of the BRC, and that notice will include the date and time for the meeting, instructions on how to attend, and the issues to be discussed. Benefit review conferences are held by video conference, that is by Zoom, and the written notice will include the call-in instructions. The benefit review conference can be held in person if the division determines that there is good cause to do so.
Okay, so in preparing for a benefit review conference, you're going to want to exchange all the pertinent information with the DWC and other parties. Now, how do you actually exchange this information for the benefit review conference? First of all, if you're exchanging with the other parties, then you can do it by email or fax. Just find out the information that you can send it to. Now, you are encouraged to encrypt documents when sending by email because that's very important. We're having a lot of private information being exchanged, and so it's just going to be very good if you can encrypt that information. And then when you're actually exchanging the documents with the DWC, there's going to be different ways that you can do that. We have an email address that's specifically for benefit review conferences and exchanging that information. You can also fax and you can mail. And then we also have the Secured File Transfer Protocol, or the SFTP. That's another way that you can upload your exchanging information. Now, if you actually check the website, we have different electronic filing options. So you can do it through the SFTP. You can also do it through our program called TextComp. However, it's more difficult to do it in that range. So I probably would refer to just doing SFTP if you're going to exchange electronically.
The benefit review conference will be presided over by the benefit review officer. The benefit review conference is non-adversarial informal dispute resolution proceeding that is designed, one, to explain orally and in writing the rights of the respective parties to a workers' compensation claim and the procedures necessary to protect those rights. Two, to discuss the facts of the claim, of John's claim, review available information in order to evaluate the claim, and delineate the disputed issues. And three, to mediate and resolve the disputed issues by agreement of the parties in accordance with the Texas Workers' Compensation Act and the policies of the DWC if possible.
Jeff, is there actually, these benefit review conferences, could I request a recording?
No. So the Texas Workers' Compensation Act specifically says that there will be no formal record taken at the benefit review conference. But during the benefit review conference, the BRO, or the benefit review officer, can ask and answer questions of the parties and other participants, encourage the parties to discuss the disputed issues and ask and answer questions, will permit the employer to present evidence relevant to the disputed issues if the employer decides to be present at the conference, and permit other participants to discuss the disputed issues and ask and answer questions to the extent the benefit review officer deems appropriate. And also, if necessary, the benefit review officer can caucus individually with each party. Kara, so let's say in this benefit review conference, John and the insurance carrier, they wish to enter into an agreement on the disputed issues. How would they do that?
All right, well, that's entirely possible. It's actually the goal of the benefit review conference is to mediate an agreement. And so if you do reach an agreement, what we have is a DWC Form 24, and this will outline the issues that you discussed and the terms of that agreement, and you'll put it in writing and everybody will sign the document. And then the benefit review officer will actually approve that document if they're able to approve it if it's actually an agreement that we can actually process at our level. And then that will be an agreement of the parties after that. And your dispute resolution process would probably stop at that point.
Let's just assume the parties were unable to reach an agreement on all the disputed issues of there being two, compensability and disability. The parties may proceed to a contested case hearing before an administrative law judge on those two unresolved issues. So when a case proceeds to a contested case hearing, the division will send the parties written notice of the hearing, which will include the date, time, and place of the hearing and information on how to prepare for the hearing. So the notice of hearing will also include a copy of the benefit review conference report that was issued by the benefit review officer. This benefit review conference report will include general information about the case, including identifying the parties and their respective representatives or ombudsman, if any. The BRC report will identify any issues that were resolved at the BRC, as well as the issues that were not resolved, together with the parties' respective position on those unresolved issues. So generally, the issues to be decided at the contested case hearings are those issues identified by the benefit review officer as unresolved after the BRC. So in John's case, there are two disputed issues to be decided by the administrative law judge. Number one, did the claimant, John, sustain a compensable injury on January 17th, 2025? And two, did the claimant have disability from an injury sustained on January 17th, 2025 from January 21, 2025 to the present?
So Jeff, what happens if we actually get the benefit review conference report, you review it, and then you notice that maybe there's something different in the issue than what you understood was going to be in the issue, or your position statement is different? Is there anything that you can do to resolve that?
Yes, there is. Rule 142.7 allows parties to submit a written response to the benefit review conference report. The response shall be in writing, describe and explain the party's position on the unresolved dispute or disputes, and be sent to the DWC no later than 20 days after receiving the benefit review officer's report, and it also must be delivered to all the other parties in the case. Rule 142.7 also allows parties to request that additional disputes be added to the case. Additional disputes may be added by unanimous consent of the parties. That is pretty straightforward. If there is not unanimous consent by the parties, a party may request the administrative law judge to include in the statement of disputes one or more disputes not identified as unresolved in the benefit review conference report. The administrative law judge will allow such an amendment only upon a determination of good cause. The DWC may continue a contested case hearing on its own motion or at the request of a party if the administrative law judge determines that the requesting party has good cause to continue the case. A request for continuance may be made before the hearing and must be in writing. It must also state the reason for continuing the hearing. It must be sent to the DWC no later than 5 days before the hearing and be delivered to all other parties in the case. Now, a party may orally request a continuance during the hearing. In this situation, in addition to showing good cause, the party must also show that a continuance will not prejudice the rights of the other parties. Also note that a continuance request made by an insurance carrier representative, a claimant represented by an attorney, and a claimant assisted by the Office of Interemployee Counsel must also comply with Rule 140.9 in that it must be in writing, include a signed statement that there were reasonable efforts to confer with the other party or parties about the request, and indicate there was coordination with docketing and the parties, and propose a new date and time for the hearing.
All right, Jeff, so John gets his notice for the contested case hearing and realizes at that point that he's not going to be able to attend that day or that time because of a previously scheduled doctor's appointment for his child or something like that. When should he request the continuance?
Well, we would encourage John to file the motion for continuance as soon as he becomes aware of the reason for the continuance. If John does submit his continuance promptly, the administrative law judge will issue a ruling on that continuance. And if the judge does find good cause, then John's case will be rescheduled, and that'll also open up that docket space for another case to be scheduled in that instead of John's case, if at all possible.
Okay, so now John is getting ready for his contested case hearing or preparing for the hearing, and the insurance carrier attorney is probably doing the same thing at this point. So what are the things that you can do to prepare for your hearing? First of all, you're going to exchange all the documentary evidence in your possession not previously exchanged before requesting additional discovery by interrogatory or deposition. So this is Rule 142.13. So what we're referring to is, remember that John, whenever he was preparing for the benefit review conference, he had submitted his pertinent information, documentation that he had to reach a resolution. And so he would need to not necessarily have to re-exchange that documentary evidence, but he would need to exchange any documentary evidence that he was anticipating on using as an exhibit at the contested case hearing that he didn't previously exchange with the other party. So he's going to need to review that previous documentation that was exchanged, and then what he does have now, if there's anything in addition that he wants to use as an exhibit, he'll send that to the insurance carrier. And you're going to do that no later than 15 days after the benefit review conference. Now, what if you have medical records that come into existence after that 15-day deadline? Then you can exchange it as it becomes available. Now, remember that not necessarily does that always mean after the deadline that it's going to come into the contested case hearing, because the judge can consider it whether or not there was good cause to admit that evidence at the hearing. So if you don't exchange your evidence within that 15 days after the benefit review conference, you do run the risk of not having that exhibit at the hearing. Now, the next thing that you're going to want to do after you exchange your documentary evidence is you can send interrogatories to the other party. Interrogatories may be used by all parties, including subclaimants, to obtain information. And so what happens is we actually have form interrogatories. The division sends out interrogatories that a carrier can use when sending to a claimant, or that a claimant can use when sending to a carrier. And then in addition to those form interrogatories, the party can ask up to 5 additional questions, and then asking just for additional information. You can also file a request for a deposition. Now, that's typically not done as much as interrogatories. I would say interrogatories are probably done on a majority of the cases, but not necessarily a request for a deposition, because usually you can get that information through different means. After you're going to do your discovery process, then you're going to exchange your exhibits, again, with the insurance carrier within that 15 days. But you're also going to send your exhibits once they are put together and labeled accurately and without any missing pages. And once you have those done, you're going to send it to DWC. We do prefer for you to send your exhibits 3 days before the hearing, and then we can go into how you're going to file that.
Okay, Kara, so if John and the insurance carrier they're going to send their exhibits to the division, how can they do so?
Now, you're going to exchange your exhibits a lot like you did with the other party in DWC as you did for the benefit review conference. And so when it's sending it just to DWC, you can either do that fax, email. The email is going to be different. It is for CCH exchanges. And then you can also send it by mail, and then the secure file transfer protocol. Now, remember, if you are sending a video, it is recommended to send that through the SFTP. It's a lot easier. It will be uploaded a lot better. And then if you're not able to do it through an SFTP, I would probably suggest that you mail it.
So let's say we have a situation where a party does not send in electronic exhibits. Can they bring paper exhibits?
You can bring paper exhibits, and make sure that you do bring copies of those paper exhibits for not only the judge, but also the insurance carrier representative, just to make sure that everybody does have a copy of those exhibits at the hearing. However, it is preferred to do electronic if you can.
So the contested case hearing in John's case. So the administrative law judge will preside over the hearing. The persons present will include John, the claimant, and his attorney or ombudsman, if any, and the insurance carrier's representative, which typically will be the insurance carrier's attorney. Now, there may be some other persons that are present at the hearing. These other persons can include the adjuster or a person attending on behalf of the employer. Now, if the claimant requires an interpreter, such as a Spanish interpreter, which we see often, the DWC will provide for an interpreter at the hearing. So John's hearing will start with the judge calling the case. The judge will identify the persons who are present in the hearing room. The judge will also identify himself or herself. The judge will identify the disputed issues in the case, which will most often be those issues identified as unresolved in the BRC report. And the judge will also admit the BRC report into evidence as an administrative law judge exhibit. The administrative law judge will also take any stipulations from the parties. Stipulations are factual matters that typically the parties don't disagree with, and they will just agree to those matters on the record, such as who the employer was, that the employer provided workers' compensation insurance coverage with the insurance company in the case. The judge will admit the exhibits provided by the parties. If there so happens to be objections raised by either party to any exhibits, the judge will listen to those objections and responses thereto and make his or her evidentiary ruling on whether or not to admit the exhibit. The order of proceedings after this will start with opening statements. The party who has the burden of proof in the case will present his or her opening statement first, which in this case will be John. If the insurance carrier has an opening statement to present next, then the insurance carrier may do so. Then after the opening statements, John will present his case in chief, which can include witness testimony. When John is finished with his case in chief, the insurance carrier will present his or her case. Evidence that we often see in these type of compensability and disability cases will include witness testimony. We also see medical records and other documentary evidence such as witness statements. Sometimes we also see the video files, as you mentioned. So after the parties have presented their respective cases, then the parties will present their closing arguments. In this case, John will present his closing arguments first. The insurance carrier's attorney will present his or her closing argument next, and then John will have the opportunity to present a rebuttal argument. Then that typically concludes the contested case hearing. So then after the conclusion of the contested case hearing, the administrative law judge will consider all the evidence that was admitted at the hearing and then issue a written decision within 10 days after the close of the hearing. Then the DWC will then mail the judge's decision to the parties.
So now what happens, you get the ALJ's decision in the mail and you do not agree with that decision. So then you will appeal that decision to the appeals panel. So what's going to happen now, let's say that John actually was determined to have a compensable injury and have disability, but the insurance carrier still maintains that he did not meet his burden of proof and he did not prove that he actually had that compensable injury. So what they're going to do is they're going to send a request for an appeal. Now, again, the request for your appeal needs to be clear and concise to rebut the decision on each issue that you're seeking review on. So a good appeal is going to specifically state the problem with the ALJ's decision. So first, state the issue that you disagree with. So in this case, it's probably going to be the insurance carrier says that they disagree with the judge's determination that John had a compensable injury or whatever period of disability the judge found. And then they're going to specify the findings of fact and conclusions of law that they disagree with, and then state the reason that they are disagreeing with the judge's decision. So that could be they believe the judge used the wrong legal standard, that the judge actually misstated the evidence that made that determination, and so they believe that the evidence actually did not say what the judge said and it supports a different outcome, meaning not compensable injury. So there's several reasons that you can include in your appeal, but again, it's just going to be very important that you include those reasons and be clear and concise so that the appeals panel can know why you're disagreeing with that judge's decision. Now, you're going to file that request for an appeal, make sure that it is in writing, and you are actually going to have to file that with the other party and include a certificate of service or just notifying us that you actually did serve the other party that appeal, because otherwise the division will have to serve the other party that appeal if it's not clear that you actually sent that to the other party.
So, Kara, is there a deadline for filing an appeal? And if so, what is the deadline?
Yes, so you're actually going to have 15 days after it's deemed receipt of the judge's decision. So in John's case, we actually have deemed receipt of 5 days mailing time. So he'd have to file it within 15 days after that 5-day period. And the 15 days does not include holidays listed in the government code. So that 15 days is not going to be an exact 15 days, and it doesn't include Sundays or Saturdays or Sundays as well. It's good to keep in mind a 15-day period, but it's not an exact 15-day period after you receive that decision in the mail.
And what happens if if a party does not file their appeal in time?
Well, if you actually have an appeal or request for an appeal that's not timely filed, or even that response to the appeal, then the appeals panel will not consider that request or that response. If it's an request or appeal, you'll usually just get a notice of untimely decision, and so the appeals panel will send you a notice that the judge's decision became final because that request was untimely. What we haven't mentioned before is actually what does the appeals panel review. So the appeals panel is limited to the record developed at the hearing and the written request for review and that response to that request for review. So at this point, it's going to be a very good idea in your appeal to actually cite to the record that you are saying either rebuts the ALJ's decision if you're requesting the review, or if you're sending in a response to that request for review and saying that the judge's decision should be affirmed or should become final, then it's just a good idea to cite in that record what supports your position on either side. So the appeals panel can issue a written decision. So let's say you send in your request for review and we agree with what you stated in that request, right? We said the judge's determination was incorrect for a certain reason. Then we can reverse that decision and either render a new decision or remand it back to that administrative law judge for further development of the evidence. We can also affirm the judge's decision in certain circumstances. So also the appeals panel has a deadline to issue a written decision within 45 days after the date the response to the request for review is filed. So what that means is that if we do not issue a written decision within those 45 days, then the judge's decision did become final, and you'll get a notice from the division that that decision became final.
All right, so next we have our hypothetical case study number 2. For this case study, let's assume that John prevailed at the contested case hearing and the insurance carrier appealed to the appeals panel, but the appeals panel let the ALJ's decision go final, and then the insurance carrier decided not to seek judicial review. The hypothetical facts in this case study are as follows. The insurance carrier files a PLN11 stating that the compensable injury is limited to a left knee sprain. John receives the PLN11 and disagrees because he recently had an MRI that showed a left knee meniscus tear, and his doctor recommended surgery. Additionally, a treating doctor referral doctor issued a certification that John reached maximum medical improvement on May 5th, 2025, with a 0% impairment rating. The insurance carrier sent the referral doctor's certification to John by certified mail, and he signed for that document on June 1st, 2025. John disagreed with the referral doctor's certification because he continues to have symptoms. He obtained an opinion from his treating doctor that his compensable injury extends to and includes a left knee meniscus tear. So John called the insurance carrier to try to resolve this dispute. The insurance carrier maintained its position, and John filed a request for a benefit review conference within 90 days after he received the certification by the referral doctor. He requests the issues to include extent of injury, maximum medical improvement, and impairment rating.
So at this point, John filed the DeWitt Form 45, and that request was approved by the benefit review officer. And so now a benefit review conference will be scheduled. So since this case actually includes extent of injury, maximum medical improvement, and impairment rating, then a BRO 1 is going to be assigned to the case as well at the same time that that BRC is scheduled. That BRO 1 is going to be responsible for contacting the parties and identifying what conditions have been accepted, what conditions have been disputed, And the reason is because they want to try to help the benefit review officer at the benefit review conference reach a mediation. So they're trying to get a certification that includes accepted injuries and disputed injuries. And remember, the division at this point is the only one that can ask a designated doctor to provide multiple certifications. And so that's why the Bro 1 is getting involved, because at that point, they can act as the presiding officer and send that request for multiple certifications. So then when you get to the benefit review conference, ideally you have a certification that will support what you've asked. And if it's only the insurance carrier, accepting what was rated by the treating doctor referral, then that would probably be what they're relying on. And then John will also have a separate certification from a designated doctor that will include a certification of what he is claiming is part of the compensable injury.
So, Kara, let's change the hypothetical facts just a little bit to say that John did not dispute the referral doctor certification within 90 days after he received it, or actually within 90 days after it was delivered to him by verifiable means. Would this change anything?
Well, actually, if the Bro 1 contacts a party and they state that there is a possibility of a finality issue, then their process is going to stop. They're not going to send a presiding officer's directive to order a designated doctor examination at that point, because there is a possibility of a pending finality issue. And so that would need to go ahead and just go to the benefit review conference and be addressed at that point.
So John's request for a BRC was approved and a BRC was scheduled. The benefit review conference will be conducted in the same manner as before, except the issues that the parties will discuss at this benefit review conference will be extent of injury, the meniscus tear, maximum medical improvement, and impairment rating. So since we have an extent of injury issue with a diagnosis of a left knee meniscus tear, which is generally considered a complex medical condition, the parties may exchange causation opinions from medical experts in this case. We also have the issues of maximum medical improvement and impairment rating, so we can expect that in this case there will be certifications of MMI and impairment rating, or maybe even a certification of not at MMI, that John has not reached MMI, from certifying doctors, including one from a designated doctor. So if the parties in this case do not enter in an agreement, the parties can proceed to a contested case hearing. So let's just assume that the parties in this case did proceed to a contested case hearing. The issues in this case would probably be as follows. Number one, does the compensable injury of January 17th, 2025 extend to and include a left knee meniscus tear? Has the claimant, John, reached maximum medical improvement, and if so, on what date? And number three, if the claimant has reached maximum medical improvement, what is the impairment rating? So the contested case hearing in this case will be conducted very much in the same manner as the previous contested case hearing, except that the issues to be cited by the judge in this case will be the extent, MMI, and impairment rating issues. Also, because of the MMI and impairment rating issues, the parties will present certifications from certifying doctors, such as the treating doctor, referral doctor, and a designated doctor, and maybe even a required medical examination doctor if the insurance carrier decided to pursue such an examination after receiving the designated doctor's report. So we would like to conclude our presentation with some links to some useful resources, including links to the DWC website, as well as the DWC hearings webpage. If anybody has any questions about the legal authorities that govern the dispute resolution system, please refer to Chapter 410 of the Texas Labor Code and 28 Texas Administrative Code, Chapters 140 through 147.
All right, well, everybody, thanks for joining us. And in a moment, we'll begin with our live question and answer session.
Okay, all right. So, well, thank you for attending today's CompCourses webinar. I hope you enjoyed learning about understanding workers' compensation disputes. And just as a reminder, you must stay for the Q&A to receive continuing education credit. We will begin with questions from the Q&A tab. So please enter your questions into the Q&A tab, and I'll try to get to everyone's questions. So, all right, let's see what we have so far. Okay, so the first question that I see is this. If the IRO and subsequent MCCH overturns a pre-auth denial, does it overturn an extent of injury dispute that was in place, or may the carrier still stand on the extent of injury dispute? So I'll answer this question as follows. So this question first talks about an IRO, a dispute of an IRO decision, and then I guess it looks like there was an extent of injury dispute going on too in this claim. So those disputes are different. They will not be heard together in our dispute resolution system. They won't be heard in the same case. And there's a reason. One of the reasons is they have different appeal paths. So in an IRO case, when an IRO issues a decision and a party wants to appeal the IRO decision, then they go directly to a medical contested case hearing. And then after that hearing, if the party wants to appeal the ALJ's decision in the MCCH, then they go to judicial review. They don't go to the appeals panel. Now, extent of injury dispute is different, has a different path. And as Kara described during our presentation, there'll first be an informal dispute. The parties will try to resolve it informally. If not, there'll be a BRC and then a CCH, and then it goes to the appeals panel, and then it goes judicial review. So I'll go ahead and answer that question as in that way. Okay, so the second question is, we need to go to BRC before submitting a medical fee dispute resolution. So I guess, do we need to go to a benefit review conference before submitting a medical fee dispute resolution? So the path, the appeals path for this, if there's a dispute over concerning a medical fee, first it goes, my understanding is to the division's MFDR section, and then they'll issue a decision. And if a party is not happy with that decision, then they could request a benefit review conference. And then if it's not if there's going to be further if a party's not if it's not resolved at the benefit review conference, then the next step is not to a CCH before the division. Rather, it's to a CCH before the State Office of Administrative Hearings. Okay. The next question is it the same process for medical billing representatives to dispute payments? I believe I would go ahead and, for this question, I go ahead and refer you to our division rules, including Rule 133.307. That rule is very detailed on the MFDR process, and that rule also identifies who can be a requester in a medical fee dispute. So, all right, let me I'm getting, just let me try to organize these. Okay, if an employer is not part of the TDI workers' compensation system, will an injured worker still be able to file a DWIC 45 against the employer if they handle their injuries within the company? So I believe this question is describing an employer who does not subscribe to who does not have workers' compensation insurance, a non-subscriber, and the answer to that would be no. Okay. Okay, what are the detailed, timely filing deadlines for the full process? Okay, that's a very broad question. There are many filing deadlines. There are many time deadlines. Um, when a case gets into the division's dispute resolution system, um, and for different actions. Uh, um, I'd refer you to our rules. Our rules are pretty clear on all the various deadlines in dispute resolution. So, for example, for the BRCs, you could look at Chapter 141 in our rules. CCH is Chapter 142, and Chapter 143 for the appeals panel. So, as Kara said, there's a 15-day appeal deadline for appealing the decision of an administrative law judge to the appeals panel. And speaking of deadlines, it's also parties also have to consider the deadline to dispute a first valid certification of MMI and IR. That's a very important deadline that parties need to be aware of. There's a 90-day dispute period. There are some exceptions to that. And one of the ways to dispute, a very common way to dispute a first certification, is by requesting a BRC. Now, these finality issues are very common, or is a very common issue that we see in dispute resolution, and they can be complicated. So I would advise parties to get with their legal counsel with help on finality issues, because it can be a very complicated issue. Let's see. I think I see is the same process for medical billing representatives to dispute payments. I think I answered that one. Let's see. Given the second scenario, if an injured worker is disputing the extent of injury, knee strain versus a meniscal tear, can the injured worker go to their treating doctor for the injured body part under their health plan when there is a dispute under workers' comp? That could be well. I don't know if I have a really good answer to that. I know there are rules that prohibit if it's a workers' compensation injury from billing the injured employee. So that could be a complicated case question. So I'll go ahead and leave it at that. See, are there detailed, timely? Okay. Okay. So this is a continuance question. Is there a set number of times a case can be reset? I don't believe there is a set number of times a case can be reset. Now, contested case hearing can be rescheduled if a party establishes good cause. That's the legal standard. So each time a continuance is filed in a case, the administrative law judge is going to evaluate their request, and if the judge determines that the request establishes good cause, then the case will be continued. However, alternatively, if the judge finds that a good cause has not been established, then the judge will deny that request for a continuance. So it all turns on whether or not a request to reschedule or continue a hearing has established good cause. And as far as BRCs, the BRC rules do have a specific definition for good cause. So I'd refer everybody to those rules in Chapter 141. In a claims office, who should be processing workers' compensation claims? Uh, I'm not sure what the question asked for. I don't know if I could answer that. I could answer if it has something to do with dispute resolution. So I'm sorry, I don't know. I'm not entirely sure how to answer that question. Uh, wh what if the employer doesn't allow you to file a dispute or you will be terminated? That I do not think that would be allowed. I don't think the employer can discriminate against. I think there are provisions that prohibit discriminating against an employee who files a workers' compensation claim and seeks dispute resolution. So there are specific statutes that prohibit discriminating against a workers' compensation uh, claimant. For the BRC and CCH, is the presiding officer a judge or a lawyer? The administrative law judge is a lawyer, is a licensed attorney. The benefit review officer at the BRC um, it does not have to be an attorney, but they are trained in mediation. Let's see, if an in-person hearing is determined to be the best option, will the hearings take place only in one area, or are there locations all over the state? So I'm going to answer this in the context of a contested case hearing. Contested case hearings are in person. Parties are required, unless there's good cause, the parties are required to appear in person at the CCH. The CCH will be held in the appropriate field office, which we refer to venue. And venue, unless there's good cause to establish another location, venue will be at the field office within 75 miles of the injured employee's residence at the time of the injury. Do you get 100% pay on workers' compensation? Refer to the Texas Workers' Compensation Act. There's lower percentages for the different kinds of um, income benefits, such as temporary income benefits and impairment income benefits and supplemental income benefits. I'd refer you to the Texas Workers' Compensation Act for that. Who has the authority to issue an interlocutory order? The benefit review officer or the ALJ? The benefit review officer does have authority to enter an interlocutory order, and the administrative law judge also has the authority to enter into an interlocutory order. And there are rules specific to that in Chapter 141 for the benefit review officers and 142 for the administrative law judges. Let's see. Can the carrier's attorney submit the injured employee for a designated doctor and RME appointments, or does it have to be the adjuster or case manager? I believe an insurance carrier's attorney can do it as their representative. Let's see. What are the steps into reverse hearing process during the appeals process? I believe that I think that's asking for what are the steps in dispute resolution, and as described in the presentation, first the parties try to informally resolve the dispute on their own, and then through a benefit review conference, contested case hearing, and an appeals panel, and then to judicial review. Okay. All right. Well, thank you for joining us today. If I didn't get to your question, feel free to reach out to me. You may feel free to reach out to me at my email address, which is jeff.carruthers@tdi.texas.gov. After the webinar ends, please take the short survey that pops up to help us make these webinars the best we can. And thank you very much. Have a great day.